Good evening, everyone. I wanted to take another opportunity to just cover contracts overall. We've been studying these for the last couple of weeks, and everyone has been doing an excellent job on their study groups. So I'm just going to take the opportunity to cover some more information about contracts. Okay, so overview. Just remember this, it's a promise. It's a set of promises for the breach of which the law gives a remedy. So if we violate it, we are we're given some sort of remedy for the lack of the performance. And the agreement creates rights and obligations that may be enforced in courts. So we have offer, we have acceptance, consideration, duties and enforcement, defenses, capacity, writing required, valid contract. So just thoughts. Contracts are the basis of many of our daily activities. They provide a means for businesses and individuals to sell and otherwise transfer property, services, and rights. And without these contracts, commerce would collapse. And the statute of limitations refers to a type of federal or state law that restricts the time within which legal proceedings may be brought. So that's a time constraint. So something might have happened, you might want to sue somebody. You always need to think about, well, what are the statute of limitations? What's my time? Is it a year? Is it 2 years? And it's very different for many different things. Two types of contracts, two classes: contracts by deed and simple contracts. So a deed is a formal legal document signed, witnessed, and delivered to effect a conveyance or transfer of property or to create a legal obligation. And informal contracts and may be made in any way in writing orally, or they may be implied from conduct. And we've had some good case study group examples of this. We have bilateral contracts and unilateral contracts, and study these. And so here's some examples of bilateral contract. Sale of goods. Buyer promises to pay the price, seller promises to deliver. In a unilateral, X promises a reward to anyone who will find his lost wallet. He's bound himself to the promise, but no one is bound to search for the lost wallet. But if Y, having seen the offer, recovers the wallet and returns it, he is entitled to the reward. So then we have types. We have implied contracts, implied in law and implied in fact. So here are a couple of examples. Implied in fact. Neighbor hires you to mow his lawn every Friday for the entire summer. You mow each Saturday morning for 3 weeks and get paid on Saturday morning. The fourth time, you mow on Friday morning. You arrive Saturday morning for payment. Your neighbor refuses to pay you. Even though nothing is in writing, the law will infer that there is a contract and he is obligated to pay you based on both parties' prior contact. So just remember that. So implied law. We have at a restaurant and a patron chokes on a bite of apple. The doctor is seated at the table nearby, rushes over to perform the Heimlich maneuver, and he saves the patron's life. He sends a bill. The customer is obligated to pay the doctor, even though he had no intent to choke and nor to use the services of the doctor. Even though nothing is writing, the law will infer that there is a remedy due. Okay. Oops. So in contract law, what do we have to kind of govern things? We have private law. That's willing parties can agree to do most anything. Freedom of contract. And then we have the UCC, which is really the poster child of uniform laws for commercial activities. It's adopted into all states, it's successful, and it really facilitates the ease of doing business. And it's the first place to look for the law. Then you look to statutes and then to state case law. And it's organized into 11 articles, and so it's something that you should understand and know that would go, you would, when you're given the question what applies, if it has anything to do with commercial activities, it's going to be governed by the UCC. Okay, so we have process mapping of contracts, and this is, where you can just go down the process and say, okay, yes, I have a contract. No, I don't. So you have an offer. Yes. Then you go to acceptance. Yes. You have consideration. Yes. So you've got everything. Then you go down to defenses, capacity, and writing required, to whether you have no contract or a valid contract. And again, we've had some good examples of these. So kind of tuck this away, and you can use this to help you down the road. So offers, showing a willingness to enter into a bargain in such a way that another person would interpret that they could accept, and it would conclude with negotiations. There is intent to have legal consequences. So can it be through words or actions? Yes. Written, oral, partly oral, and written. Advertisements can be offers. Negotiations are not offers. Buyers have to be able to walk away from estimates or price quotes. So again, that's part of the UCC, and it really gives some good direction and guidance and protection. Death of an offer. We have a figurative death of an offer and a literal death. So a literal death, we can jump down there quickly, is the offeree dies, destruction of the subject matter. We enter into an agreement to buy the house burns down. So the literal death of an offer. Then we have the figurative death. You have natural causes, which is time. That's why whenever we enter into a contract, there's usually a lapse of time. If you think about purchasing a home, you have a period of time to revoke or continue forward. Revocation can apply to suicide and murder. And execution by operation of the law, a change in law terminates the offer too. Some changes to my slide here. Acceptance, achieved consensus, a meeting of the minds. So once an offer has been made, the other party can accept it in any reasonable way, including starting performance. I don't have to say, okay, I can just go start performance, and that is an acceptance. The party who accepts can back out up until performance begins. Factors include, were terms finalized, and did performance begin? And I'm actually going to post a contract, so you'll have a good idea of what we look at, the components of a contract when we do that. A contract must include a promise and a return promise. It cannot go one direction. Both parties have to get something. So we have the performance or a product, and we have the consideration. Usually it's a good or a service. A promise is not enforceable because one party gets nothing. So think about that. I know there were some questions around that from one of the groups. The exchange does not have to be equal. One person can value something more than someone else. Beauty is in the eye of the beholder. Enforcement, substantial performance. So what does this mean? This is doing exactly what is in the contract. Is not always possible, but the parties have to reasonably live up to the terms. So that's substantial performance, and a judge can request that too. If one party does not materially perform, the other party no longer has to perform. So I don't have to pay if you don't materially perform. Failure to perform is called breach. So what happens when somebody breaches? We receive damages. The party who is harmed can request money or specific performance. So this is where the judge can say, okay, if it's still possible to perform, I am going to force you to do it. The court can require the party to perform. So what are some of the defenses that we can use not to perform? And this often comes up when businesses try to trick poor and uneducated clients too. Certain things can make contracts void even though both parties agreed and there was valuable consideration. Unconscionability. Oh, I can't even say that. If one party tricked another into agreeing to an unfair contract, then the court may not enforce it. So that's you have to look at these things when you're creating your defense as to why the performance could not occur. So other defenses are fraud, duress, misrepresentation, and capacity. Lying or misrepresenting something in negotiations can always make a contract void. Is taking advantage of someone in a situation can make a contract void. If a company knows about a flaw in a product and covers it up, contract can be void. Legality. If the terms of a contract require illegal behavior or if they go against Congress stated goals, it will be declared void. And capacity. So several of you also discussed capacity. Parties must be legally capable of entering into a contract. Enforceability. Void contracts. The whole transaction is regarded as nullity as though there has been no contract between the parties. Goods or money obtained under the agreement must be returned. Where items have been sold to a third party, they may be recovered by the original owner. And a voidable contract will operate as a valid contract unless and until one of the parties takes steps to avoid it. And in some contract language, you'll see that there is language that will say part of the contract can be null and void, but the rest of that, the contract will be required to be performed. And often you'll have that, most often that language will be in there. So read through the rest of it. I'm not going to continue to read these slides, but there are good pieces of information that you should have. A contract can only be formed in writing. Yes or no? Words are necessary to create a contract. Quasi-contracts are also called implied in law contracts. Rejections must be communicated. Can't spell. So answer these questions. I'm not going to give you the answers here in this in this brief video. These are some things that I just want you to know, and you should be able to look these up and understand them. Thanks for joining me tonight. Have a good evening.